SJC-10871, Commonwealth versus Leng.
Let's proceed.
May it please the court. Once again, I'm here because of what I perceive to be a senseless act resulting in the death of an individual, and all that happened afterwards just confuses the situation immensely. Let me say at the outset, though, that I would like to stress the fact that it is important for this case to be decided pursuant to your statutory authority. And the reason for that is because I do not come here with any errors that were preserved. All of the errors I found during my review of the transcript and of the file, there was no objection on which we could hang our hat. And so, as we do quite often, we ask that the case be sent back to the Superior Court pursuant to a motion for a new trial filed up here, so that these errors might be considered by the trial judge. That happened in this case without success. And so I'm back to you requesting as strongly as I can that you consider these perceived errors collectively, not singularly, but collectively. There were, in my view, 4. The first was the failure to preserve the, for appellate review, the issue concerning gang evidence going in at trial. The second is the failure to present any evidence of the defendant's intoxication at the time of the crime. The fourth is the failure to request a voluntary manslaughter instruction. And the fourth, was the failure to protect the defendant's right of confrontation. The facts are routine as far as I'm concerned. We have here, as I said, another senseless act. The defendant and his friends were attending a party in Lowell on the night of, I believe, October 3rd of 2006. A fellow by the name of Corey Nealon, a friend of the defendant's, was drinking beer from a keg. However, when the keg broke, he saw some bottles and he asked someone, we don't know who, if he could have a bottle of beer, and he was told that he could. However, it would appear that the person who gave him permission did not have the authority to give him that permission, and so when Corey Nealon started to drink from the bottle of beer, he was confronted by a fellow named Joshua Gins, who presumably had brought the bottle of beer into the party.
And he was later shot.
Yeah, he was the one who got shot. He got shot over his bottle of beer.
Over a bottle of beer?
Over a bottle of beer, yeah. Yeah, his bottle of beer, yeah. So, even though, and the evidence is sort of skewed, I'm not sure whether or not Corey Nealon could have had a bottle of beer, or whether or not he rejected the fact that he was offered some keg beer after they fixed the keg. I don't know, but it's kind of an odd situation. But in any event, when Joshua Gins told Corey Nealon that he could not have the beer and took it away from him. The result was that Cora Nealon was hit over the head by Gins with a bottle. And of course, this resulted in an altercation involving a lot of different people. A lot of people were involved. It is not clear from the transcript and from other documents in the file just where the defendant was at all of this, when all of this was going on. He was somewhere there in the party, we know. Whether or not he was involved in the altercation when it was limited to beer bottles and fists, or it just
Well,
doesn't.
there was a chair in there, too. wasn't there?
Somebody hit, what's the name, with a chair.
That's right.
With a chair, yeah.
Yeah.
But I don't think that was the defendant. I don't think he did it. But in any event, and only one person is able to testify about what actually happened when the defendant spoke to Cora Nealon. According to Cora Nealon and nobody else, the defendant said to him, as he saw that he was bleeding, "Who did this to you?" And Cora Nealon pointed out Mr. Gins, whereupon the defendant, who, according to other testimony, already had the gun out, then he turned and fired, killing Mr. Gins. Well, you see what I mean when I say a senseless act.
Counsel, the defense at trial was misidentification, is that correct?
I don't know what the defense was at trial, to be perfectly honest with you. I know that trial counsel did a heck of a job in the cross-examination of Cora Nealon, pointing out all the different stories he told, the different lies he told. And
Mr. Nealon was one of the Commonwealth's witnesses. Was there
Yeah.
another eyewitness as well?
But nobody else identified anything that the defendant did. Cora Nealon was the only one to say that it was the defendant with the gun who fired. Okay. And Cora Nealon, of course, first denied anything. He lied to the police about everything. And it was only after he was told that he would not be charged that this particular version emerged. Now, we're not here to assess the credibility, of course, but I find it kind of odd.
Well, that was, I take it as you suggest, that was fully explored on cross-examination.
Absolutely,
Okay.
Absolutely. He did a hell of a job on crossing Mr. Cora Nealon about the different versions he'd given and the reason why he was now testifying. Great job.
Was the defense that the Commonwealth basically didn't prove its case?
Well, you know, they proved that, of course, Mr. Gins was killed, but I don't know if they proved who actually did it. He was killed during this altercation, which resulted over the beer.
Yeah.
But whether or not it was the defendant, I don't know.
So essentially, identity is the main issue in the
Absolutely. Among those involved in the altercation, which one of them did it? Mm-hmm. And they opted not to charge all of them, which probably made good sense. But the point of the matter is that Mr. Cora Nealon was the only witness who testified that it was, in fact, the defendant.
Well, if he was the witness who testified that the defendant did it, wasn't it then within the jury's purview to determine whether or not he was believable, whether they accepted that?
Of course. And that's why, one of the reasons why I think trial counsel did a hell of a job, because he pointed out all the different lies that were told, and he pointed out the reason why he was doing it. But in a case like this, if that's the only game in town, that's the game you play. Nobody else was accused. One thing for certain, Gins was dead, and he got shot right there at that party over nothing. But, hey, it's the only game in town, Judge, and as a juror, you got to say that you can't blame the jury here for saying, okay. But I think, and this is only from the years of experience of doing this, that it was easy for the jury to choose to believe that it was the defendant and
that
no one
because of the
else.
gang evidence?
I'm sorry?
Sorry, I'm just
Because of
gonna-
yes, because of the gang evidence, which was totally unnecessary. It was unnecessary because as I viewed the transcript and the record, I saw nothing to indicate that the victim, Gins, was a part of a gang or that this was a gang-related incident. This was a party in which a lot of people were invited. Sure, some parties were
But
attending.
was there evidence that Mr. Nealon was a member of a gang? with
Yes.
And that there was a gang kind of a culture?
No. Well, I back up. Let me square that away. Yes, you might say a gang culture because he was permitted, and there should have been an objection to this, to testify about the importance of being a member of the gang because one of the responsibilities is to cover each other's back. And in reading this, I said to myself before going to the end, he's dead in the water. Dead in the water. Because if that is the purpose of a gang relationship, then the defendant had no chance. Despite the fact that this was not a gang-related incident. There was nothing to indicate that Gins belonged to a gang. There was nothing to indicate that Gins and his friends attending the party had any beef with the so-called dangerous Lowell Bloods. This was the gang that Mr. Nealon belonged to, and he said that the defendant belonged to it as well. Now, he was the only one who said that the defendant belonged to the dangerous Lowell Bloods. Nobody else gave that testimony. So I assume that if he's believable, then maybe that's what it was, that he was a member. But he went further than that, pursuant to questioning by the district attorney, to testify that prior to that he had taken the defendant to Leng, I believe it was, where the defendant purchased the gun that he used that night, and where they stopped on the way back, so he test fired it to make sure it was operable. I don't see how that was necessary or relevant or introduced for any reason other than to
Well, how
prejudice
is that
the
gang
defendant.
evidence?
I'm sorry?
I'm sorry, I don't understand how that is gang evidence. That's just,
It's not,
that's,
but-
what you're complaining about now
I'm
is
saying
not.
it's not. I'm saying it
Okay.
shouldn't have been admitted. Absolutely not.
No, but your complaint is that it was ineffective assistance for him not to have tried to exclude gang-related evidence. And what you're just describing is not gang-related evidence.
But it wasn't excluded. And I think the defendant should have tried to, the counsel should have tried to exclude it.
But wasn't it relevant?
But it took on added significance when you considered it in connection with being a member of a gang. It took on added, if these two were just friends, and I drove him to Leng to get a gun, and there's no evidence of a gang, then it would be incumbent upon them, the prosecution, I believe, to show that the fact the gun that was bought in Leng was in fact the gun that was used to kill. But there was no evidence of that effect except from the testimony of Mr. Corey Nealon, who by this time had made every sort of deal that you could possibly make and had been impeached thoroughly, in my opinion, from reading the transcript. Let me move on. The trial counsel also knew, or at least the defendant says he told him, that he was drunk. Well, it's a party. Everybody's drinking, so it's reasonable to believe that the defendant could have been drunk, but there was no evidence presented to this effect. The defendant in his affidavit in support of the motion for a new trial said he was very drunk and that he told counsel this. However, there was no hearing on the motion for a new trial, so there is nothing before you other than the affidavit of the defendant. I had requested a hearing, but the Superior Court judge decided in her infinite wisdom that it wasn't necessary, and I'm not quarreling with that, but wouldn't it be nice if there was some testimony under oath that you could review to say that, well, on this, the defendant was intoxicated.
Yeah, but if the thrust of the defense is he didn't do it, somebody else did it, why would you want the jury to think if I did it, I was drunk?
Look, no, you don't give them an alternative like that. But you have to present every piece of evidence that may be favorable to you, no matter what. Many lawyers have found himself on the brunt end of ineffective assistance because he did not pursue more than just one defense. He honed in on one to the exclusion of everything else. And
Do we have any sense, Mr. Davis?
I'm sorry?
Do we have any sense from defense counsel as to why he made this apparently strategic decision not to bring out the defendant's intoxication through Mr. Neeland?
No. Okay. Nothing at all. Of course, if there had been a hearing, he would have been called as a witness, but since there was no hearing, he was not called.
And you didn't present his affidavit?
I ask, I can't compel.
Fair enough.
Let me...
Fair enough, I said.
Okay, okay. Let me move on. The other thing that really struck me as odd is the fact that defense counsel agreed that a manslaughter instruction was not necessary. This is where trial counsel and I really part company. If there is any situation where a manslaughter instruction would be appropriate, it's just when a shooting or killing takes place as a result of a brawl.
May I ask you, am I right on the facts that at some point someone with a gun said,
who did it?
Who's going to die, or who's ready to die, or words to that effect?
That was somebody, but said that that's what they heard, but they didn't say that it was the defendant who uttered those words. What got the defendant was the testimony of his friend, Corey Neeland, who testified that the defendant said, who did this to you, when he saw him bleeding. And when he pointed out the guy who did it to him, that's when the defendant fired the gun. The evidence is a little hazy, too, as to where was the defendant during this altercation where people were being hit over the head with chairs and fists were flying. I don't know if he was involved in that or not. There's no evidence that he was there. The evidence seems to indicate that once he saw his friend bleeding, that's when he pulled out the gun, according to Corey Neeland. So it is a little bit hazy. I don't know. But in any event, this was a shooting which resulted from an altercation involving several people. And out of an abundance of caution, if for no other reason, a trial judge should give a manslaughter instruction.
To a sponte?
If necessary. If necessary, because trial counsel does not come to play every day, as obviously it was in this particular instance. It did a hell of a job when it came down to cross-examination of the witness, but when it came down to vital points which may be reviewed on appeal and may result in a reversal of a conviction, had the issue been preserved, he didn't come to play. It's not unusual. I can recall several days I didn't come to play. And would you believe, Judge, I have filed a motion for a new trial in a case alleging ineffective assistance of counsel when I was trial counsel. An issue that's just pending down in the federal court right now. I don't know what the outcome is going to be, but I'm prepared to take my medicine because I did not come to play that day. It was simple as that. You're not on your A game every day. Sometimes, you sort of leave it back at home or something. I don't know what happens.
You focus on one thing and not something else. That happens.
I'm sorry?
Yeah, you focus on one thing and not something else.
That's true.
On one thing and not something else. You have a strategy in mind, and maybe you don't pay enough attention to some of the other pieces.
Absolutely. And it pains me, of course, to bring an ineffective assistance of counsel claim, but they understand that that's the job that I have, and that's the job that they have. The only thing that bothers me is that when they know that I'm going to do it, I should receive some cooperation, but very seldom that you do. Lawyers are funny out there these days, you know. They don't want you to think that you think they were ineffective. Well, that tells me that they don't have the best interests of the client in mind.
Can I ask you this, Mr. Davis? I know your time is running out, but on the last point, the failure to object to the substitute medical examiner.
Yes.
Was cause of death in any way, manner, shape, or form an issue in this case?
I can't say that. All I know is that he was shot, and he died as a result of being shot. But, you know, the thing here that I think I pointed this out maybe in the footnote here, that during the time of the autopsy here, the medical examiner's office was undergoing scrutiny. And the medical examiner who conducted the autopsy was not available, and there's nothing there to indicate that why he was not available. Could it have been he had been fired? I don't know. If he had been fired because he was not doing a good job, wouldn't that have been important? Because the substitute medical examiner had to testify based on the medical examiner's report that conducted the autopsy. And what if that guy had made some mistake? Another thing, there were some pictures involved. I don't know how they got into evidence, but I have a case pending right now up here where the police officer attended the autopsy, took the pictures, and it was a police officer who testified at trial that, yes, these pictures were taken by me and they were introduced in evidence as a result of his testifying. And then the substitute medical examiner testified about what he observed in the pictures, and we go from there. So there was a lot wrong there that, well, I won't make this argument when I come back on another case.
Thank you, Mr. Davis.
May it please the Court. Good morning, Your Honors. Stephen Hochter, Assistant District Attorney from Middlesex on behalf of the Commonwealth. Your Honors, there was no ineffective assistance of counsel here. There was no substantial likelihood of a miscarriage of justice. If there were any errors, they were unlikely to influence the jury's decision to convict the defendant. The evidence of the defendant's membership in the dangerous low bloods was relevant and admissible to his motive to commit the crime. The judge also gave the jury a complete picture and context for the crime.
Well, I mean, this is not a case in which the victim is somehow proven to be a member of a rival gang or anything like that.
That's correct, Your Honor.
So it's not that tension. So the theory here is he shot the victim because he was protecting a fellow gang member as opposed to a fellow friend with whom he came to the party?
That's correct, Your Honor. It was in retaliation for the victim hitting Corey Neal and a fellow gang member over the head with the beer bottle.
Well, if he'd been a friend, I mean, wouldn't that also have been, I mean, does it matter that he was a gang member as opposed to a friend?
Yes, Your Honor, because the jury heard evidence. Nealon testified about the gang culture. He testified about how once he was a member of the gang, they taught him that you have to watch each other's backs, you have to provide food, shelter, things of that nature for a fellow gang member. The whole code, quote unquote, of the gang, don't talk to the police, which was later explained at the trial when he explained why he first lied to the police and then eventually he agreed to testify for the Commonwealth. But the judge took great pains to ensure that there was no prejudice to the defendant.
How did he do that?
He asked the jury during impanelment, the prospective jurors, about that, if they would be able to still act impartially after hearing that evidence, and that's in this transcript, Your Honor.
Yep, sure, I understand that.
He also, she also gave limiting instructions when that evidence was introduced, every time that it was introduced, pretty lengthy limiting instructions, about 3 pages of the transcript worth. And then in her final instructions to the jury, gave them another instruction that evidence only went to the defendant's state of mind and intent and motive to retaliate with regards to the homicide of the victim, and was not to be considered as propensity evidence of his propensity to commit the crime that he was charged with.
So the only gang evidence came in through Mr. Nealand,
That's correct, Your
who
Honor.
was also the only witness who identified the defendant as the shooter?
No, there was another witness that also identified the defendant as a shooter. That witness was Bunrath Law, and he was the person. He was described throughout the transcript as the person that came into the kitchen after Nealon was struck with the bottle, and he broke the chair over Joshua Gens, the victim's back. But he was also a gang member, and he also identified the defendant as the shooter. The defense,
Same member of the same gang?
yes, the dangerous low bloods.
So did he also testify about gang culture and?
He testified about the incident. I don't think my recollection, Your Honor, I have to look back at the transcript, was that he didn't get into as much detail. He testified that he was a member of the gang, but he didn't testify about the culture.
Okay, but he identified the defendant as the shooter?
He did also, Your Honor. And that was the theory of defense in this case, was that the other witnesses that were at the party didn't identify the defendant as the shooter. They said they heard a shot. They saw the defendant with a gun, but there was one witness who had brought the bottled beer along with Angel Madeira to the party, David Nino, and he said he heard the shot and he saw the victim fall to the floor, but he didn't actually see the shot. And so the defense theory of the case was that the witnesses that couldn't identify the defendant, there were some that couldn't, and then the two fellow gang members that could identify the defendant and did at trial were not credible witnesses. And that went to the intoxication defense that, and again, I'm speculating because we don't know what defense counsel exactly was thinking, but he may have refrained from an intoxication defense because he would have had to argue to the jury. He would have to establish that defense through Corey Nealon.
But, I mean, why would that be inconsistent? To ask Mr. Nealon questions about the drinking at the party and the defendant's intoxication. How would that be inconsistent?
I think it would be inconsistent, Your Honor, because he attacked his credibility throughout his cross-examination and his arguments to the jury, and then he would be relying on him to establish that defense. But there wasn't, in any event, even aside from that, Your Honor, that may have been a strategic decision, but there was no evidence to support an intoxication defense.
Well, was there any evidence as to when the defendant arrived at the party, for example?
There was evidence that he arrived. I'm not sure if the time was in the record. I think it was just that he arrived with Law and Nealon at the party. But there was no testimony about what he had to drink or if anybody saw him drinking anything. There was testimony about Nealon drinking from the keg, and then he wanted the bottled beer, and that's when the fight started. But there was no evidence about the defendant drinking or anyone seeing him drinking at the party.
Well, I mean, that's the point. The defense counsel have an obligation to bring some of that evidence out. I mean, if he'd been at the party for, I don't know, that's why I asked you, when was there any evidence of when he got there? It was a keg party, so people obviously were drinking beer.
Yeah, there was nothing in the record about when the party started. He got there, and then when David Nino and Angel Madeira, they testified that they got to the party at 9 p.m. But I don't know when the defendant got there or Nealon. I think it was roughly before that, but I don't know the exact time frame, Your Honor.
And we don't know if there was any consumption of alcohol or other substances before they arrived at the party either.
That's correct, Your Honor. That's not in the record. Just briefly, moving on to the manslaughter instruction, there was no basis in the evidence for a manslaughter instruction. In fact, the trial judge found that, and defense counsel agreed with him. There was no provocation. There was no valid claim of self-defense or excessive use of force in self-defense, and there was no basis for an instruction in defense of another here. So for defense counsel to request a manslaughter instruction would have been futile under these circumstances. There was no ineffective assistance in his choosing to refrain from requesting a manslaughter instruction. As far as the testimony of the substitute medical examiner, Your Honors, that testimony was based on his own conclusions and not the conclusions of the medical examiner who performed the autopsy. And again, the cause of the victim's death was not a substantial issue in this trial. So again, there was no ineffective assistance there. with regard to that argument. And finally, Your Honors, I would ask that this court...
Didn't the substitute examiner,
Sorry, Your
though,
Honor.
weren't there several questions based on the factual findings of the autopsy report and not on his own findings?
Well, there was a time in the direct examination, Your Honor, where he started to say something about what was found, what Dr. Croft, who was the medical examiner who performed the autopsy, what he found, and the prosecutor stopped him and said, no, not what Dr. Croft found. What your opinion is based on reviewing the autopsy report, the medical records, and the photographs of the autopsy. But the autopsy report and the photographs of the autopsy they reviewed, they were not submitted or offered by the Commonwealth into evidence. It was only his opinion based on his review of those records and the photographs. Finally, Your Honors, I would just ask this court to deny relief under Section 33. The defendant's murder, this murder was premeditated and deliberative. The defendant, after the fight, came into the kitchen. There was testimony that he was waving a gun and asked who wanted to die, and then he shot the unarmed victim in the chest and killed him.
All right, thank you very much, counsel.
Thank you, Your Honors.
We'll take a brief recess.